So the MK party is asking Chief Justice Mandisa Maya to postpone an upcoming Judicial Service Commission sitting. This is to allow the party more time to file its application for leave to appeal a Western Cape High Court ruling. The Cape Town court on Friday prevented John Hlophe from attending Monday's meeting. The party says a recess by the National Assembly is also preventing it from sending another member of parliament in Hlophe's place. It argues that the JSC sitting won't be properly constituted. Hlophe was impeached as a Western Cape judge president for allegedly trying to influence Constitutional Court justices. Professor Pierre de Vos, a constitutional law expert with the University of Cape Town, is now joining us for this conversation. Professor de Vos, a very good morning to you. Thank you so much for making time for us. Is the MK party right in their interpretation of what a properly constituted JSC is if there is a decision that has been taken by a court to say that one of its members should be barred from attending the next sitting?
Well, superficially, they seem to have a strong point because there are two judgments from the Supreme Court of Appeal that made this point, that said that unless the people who the Constitution Section 1, the Constitution says must be on the JSC when a decision is taken, unless they are there, if they are not there, then it's not properly constituted. But in one of those judgments, the Cape Bar Council case, the court also said this is only so if it is not impossible for that person to be there. In the law, there's a maxim that says the law doesn't expect the impossible. And so if somebody cannot be there, and the argument here would be Dr. Hlophe cannot be there because the court has prohibited him from being there, there would be a case. So I don't think, given that exception, the case is winnable. It's not a far-fetched argument, but yeah, I think in the end it is not going to be successful, probably.
Yeah, because they go on to argue that even if they were to replace John Hlophe, currently the parliament is in recess. But also if you look at section 178 of the Constitution on the Judicial Service Commission, 6 persons designated by the National Assembly from among its members, at least 3 of whom must be members of the opposition parties represented in the Assembly. So in the absence of John Hlophe, that would mean that there will only be 5 persons designated by the National Assembly.
Yes, so as I've said, the previous cases dealing with the presence of a premier, in the case of disciplining Dr. Hlophe, in fact, in that case, Dr. Hlophe took exactly the opposite position of what MK is taking now and said it didn't matter. Obviously, in those cases, if the people who are designated or who should be there can be there and they're not there, clearly the JSC is not properly constituted. In this case, there is a court interdict, rightly or wrongly granted, which now says the one of the 3 MPs from opposition parties is prohibited from participating in the JSC, which seems to make it then impossible for that person to be there. So unless Parliament can designate somebody else in the meantime, I don't see how the matter, how the matter could be postponed for or could be postponed merely because the court has said that has given an order. And
that's the thing, right? Even though that it is a court order, does it have the effect of a JSC not being properly constituted? And the matter that you are relating to now, or relaying, the one with the Premier, it's actually a matter relating to this allegation, or the allegations that were made against John Hlophe, where Helen Zillers, the Premier of the Western Cape, was arguing that I wasn't part of the JSC meeting that led to the final decision that was taken, that John Hlophe doesn't have a case to answer before the JSC. And the court's final decision on that matter was actually the Premier must have been part of that panel.
Yes, but as I've said, the court has also said that this is the case, except Actually, not in the Premier case, in the Cape Bar Council case, they said this is the case unless it is not possible for that person to be there. One could imagine, for example, if one of the people designated to be on the JSC has a car accident the night before the event, that person is in the hospital on life support, it is impossible for that person to be there, and then clearly the JSC should go forward. They would be properly constituted. The dispute in this case would then be if a court order that prohibits a person from being there, if that makes it then impossible for the person to be there. My view is that it would, but of course, it would be interesting to hear the arguments to the contrary.
Yeah. Does the JSC have the powers to postpone an upcoming meeting on the basis of there is a lack of clarity around whether or not it would be properly constituted if those meetings, including the interviews, do go ahead?
Well, the JSC can decide when they are going to have hearings, yes. In principle, it is possible to do that. Whether it is appropriate and whether it might not undermine the courts and undermine the interim interdict and the court that gave that interdict is, of course, a difficult question, because it will in effect undo the interim interdict of the High Court if the matter is postponed indefinitely until such time as the courts have resolved this, which is going to take a while because it will go up all the way to the Constitutional Court, so a year or two.
Yeah, and actually the Western Cape High Court does speak about that tooth and nail battle that the MK party as well as Dr. John Hlophe would be bringing. The other argument is around a quorum. What constitutes a quorum for the JSC? That, let's say, a member is incapacitated or perhaps the member has fallen ill, whether or not the JSC would be able to go ahead with its interviews, even though some of its members are not there?
Well, the members need to be there because the Constitution designates them, and all the different kind of nominees play a different function on the JSC. So unless it's impossible for them to be there, they have to be there. There's not a quorum in the normal sense of the word, where only 2/3 of the members or whatever need to be there.
Okay, so so does this mean that all 23 members need to be there?
Yes, unless, of course, it is not possible for them to be there, as the courts have said.
Yeah. If you were to receive a call right now from Chief Justice Mandisa Maya, how would you say she should deal with this matter?
Well, as I understand from News 24 report, the JSC did meet last night virtually and decided to go ahead with the hearings. So it seems to me, while it's a difficult decision because there's also politics involved, this is not really, in essence, a legal fight. It is ultimately a political fight. And so the JSC is in an impossible position, not wanting to get embroiled in the politics, but also having to do the principal things. In my view, it's probably the correct decision to make sure that the political fight doesn't undermine the courts and undermine the interim order that was granted last week.
Yeah. Another aspect to the judgment that was handed down last week is around the powers of the National Assembly, and the point that was raised that the National Assembly is not obliged to simply rubber stamp a nomination that comes from the opposition. What does this then mean going forward around how the National Assembly would have to deal with matters relating to members being nominated from the opposition or any political party for that matter?
Yes, so this was an interim interdict, so the court didn't actually give any binding, the decision doesn't establish a binding precedent. This is for me, one of the difficult aspects of this case, because if the suggestion of the court now, we will see what the court, when they deal with the merits of the case, say, but the suggestion that there is a general discretion for the National Assembly and for the majority to decide which of the MPs of opposition parties should be on the JSC and to veto some people, that is potentially problematic because that gives the power of the majority the power to basically select the people from the opposition that they want on the JSC, maybe more pliable people. So I would hope that in the final case, when the merits are decided, that the court is more subtle about this and maybe say that as a general rule, the custom that has developed that the National Assembly will not interfere remains, but there may be a specific exception in cases where the person nominated is not fit and proper.
Yeah.
Whatever.
And that's the other part, is around that test of fit and proper. How do we determine whether a person who is fit and proper to become a member of parliament is not fit and proper to be nominated as a representative of that very same parliament in the JSC? But the point that's made in the court judgment as well is looking at the obligation of functionaries of the state around Section 165, how to ensure that you also protect the judicial independence and the courts.
Well, one doesn't have to be fit and proper to become a member of the National Assembly. You only have to be somebody who has not in the last 5 years ended the prison term of more than 1 year or have been insolvent or whatever. So it's not a requirement. One of the issues in this case is exactly when you're going to sit on a body that selects judges who have to be fit and proper, should there not be a requirement that you yourself should at least have some minimum integrity, or should not have been impeached, or whatever the case might be? And the reason why it's a controversy is because the Parliament hasn't dealt with this before. There is no rule for it. It assumed that it shouldn't interfere in this case, but there is obviously an issue. If you have been impeached, you're clearly not a fit and proper person in legally speaking. Should you be on the JSC? I don't think one should be. Whether the rules allow for the National Assembly to stop it, that is a much more complicated issue. I'm not sure what the answer is.
Yeah, and the point that has been raised before also, if you look at the Menzi Simelane matter, that the president at the time shouldn't have ignored the Ginwala Commission's report and the findings against Menzi Simelane, and therefore the decision to appoint him as NDPP was improper. Can a similar argument be used when it comes to the National Assembly?
Yeah, I've heard that argument made. I'm not sure it can, or it's slightly tricky in the sense that in the Simelane case, the appointment criteria for the National Director of Public Prosecutions clearly said that the person had to be suitably qualified and, the appointment was linked to the independence and integrity of the National Prosecuting Authority. In this case, there are not clearly qualifications prescribed or suggested in the Constitution for the people who sit on the JSC. So one has to derive that from a general obligation elsewhere in the Constitution that organs of state has to protect the independence of the Constitution. So it's a little bit, the link is slightly more tenable, tenuous. So it's an argument. Whether it should fly is again debatable.
In that letter again that the MK party sent to the JSC, they said that they need a response by 11 o'clock today. Otherwise, they're going to take this matter to court. How do you think this would play out, though?
Well, I don't. If they're going to appeal the interim interdict, they have a problem because one cannot normally appeal interim interdicts unless they are final in effect, and I don't think this one is final in effect. So the appeal, that is not going to be a helpful way of dealing with it. Whether they bring another application, I don't know. But as I said, if the news reports that appeared this morning are correct, that the JSC is going ahead, we will see what the MK party decides to do in response. The appealing the interim interdict, I think, is the weakest of the legal options in this case.
Yeah. Thank you so much for your time. Professor Pierre de Vos, the constitutional law expert.